You're detaining me.
I'm not detaining you.
So you just said to me I'm not going anywhere at the minute.
Listen, where do you intend to go next? Because I'm just going to follow you, right?
In this video, Forced Awakenings is filming outside a council building. Nothing covert, nothing hidden. Just standing in a publicly accessible space with a camera. But the response? Immediate escalation. Officers approach as if they've intercepted someone scouting a restricted compound. No groundwork laid, no clearly articulated offense, just instant demands for his personal details. When that angle doesn't hold, they pivot. The Terrorism Act gets mentioned, not because there's evidence supporting it, but because invoking it sounds serious. As if saying the word alone is enough to elevate authority. Seizing his camera gets floated. Arrest is hinted at. And even when he disengages and walks away, they follow behind him, treating lawful filming like something that needs to be hunted down. It's one of those encounters where escalation comes first, and the legal reasoning gets pieced together afterward. And that sequence matters because in policing, justification is supposed to precede authority, not chase after it.
I'm just wondering what you're doing.
I've just explained to one of the civic enforcement officers I'm filming.
What are you filming?
Anything I can see from public.
Right, and is there a reason behind that?
It's for a story.
Right, okay, can I take your details, please?
What would you like my details for?
Because obviously in the interests of public safety and everything like that, when somebody is out filming and having a look around public buildings,
right,
we have a duty of care,
right,
to check you out.
What, a duty of care to whom?
To the general public.
I'm part of the general public?
Yes.
I don't have to give you my details then?
Right, I can just get other people.
Well, other people, I'm still not obliged to give you my details.
I'm asking because
I'm
at the
refusing.
moment, I don't know whether you are committing any criminal offences in this area.
I'm certainly not.
This gentleman is out filming and is pointing up, looking at all the cameras, and obviously in light of...
Identify the cameras up there?
In light of...
I'm not filming that. I'm filming up there. I was filming up there when this lady approached.
She opens in full interrogation mode from the first sentence. No conversation, no clarification, just immediate scrutiny. And even after Forced Awakenings calmly explains why he's recording, she treats his explanation like it has to pass her personal approval test. It doesn't. Lawful activity does not require a justification that satisfies an officer's curiosity. Rights aren't conditional on whether an explanation feels good enough. Then she pivots to public safety and a supposed duty of care as grounds to demand his details. That's a stretch. Duty of care isn't a roaming authority to gather names from anyone holding a camera. It applies where there's a clearly identifiable risk, not where there's mere uncertainty or discomfort. And then comes the most revealing admission. She concedes she doesn't even know whether he's committing an offense. That's the pivot point. If you cannot articulate a crime, you cannot manufacture grounds to demand personal details just in case one might exist. Policing operates on reasonable suspicion tied to specific conduct, not on open-ended fishing expeditions.
What's the issue?
There isn't an issue.
I'm just wondering why he's filming public buildings.
Yeah,
I'm perfectly entitled to film anything I can. Hang on, wait a minute. I'm perfectly entitled to film anything I can see from a public place, including council buildings that are owned by the public.
Okay, we have concerns about public safety.
And your concerns are?
We don't know who you are.
That's
and what
not a concern.
Links it is.
It isn't.
In the day and age that we are in.
Are you accusing me of being a terrorist?
I'm not accusing anybody of anything. But
do you have reasonable suspicion to believe that I'm up to anything other than?
I don't know what you're up to.
Go on to Google filming in public. It'll and even legislation.
Don't tell me what I need to do.
Right. Well, don't tell me that I need to give my details when I know that I don't.
I'd like you to move away from this area, please. Otherwise,
you need a section 60. You need to remove somebody from an area without probable cause. You need a section 60.
Well, I'm concerned for public safety and what you are doing in this area.
Well, I've told you what I'm doing in this area.
Well, you need to move away from here.
When the second officer arrives, you'd expect a reset, a fresh assessment of the facts. Instead, the mindset hardens. Between them, filming a council building is treated as inherently suspicious. Not because of anything specific he's done, but because it doesn't match what they expect to see. And that's the real driver of the encounter. Expectation, not evidence. The focus keeps circling back to identity. I don't know who you are. As if unfamiliarity itself creates authority. It doesn't. In a free society, anonymity in public is not a red flag. It's normal. The inability to recognize someone isn't grounds to demand their details. Then comes the familiar phrase, in this day and age, it's the rhetorical bridge to terrorism, floated without any tangible link to the person standing in front of them. No hostile reconnaissance, no suspicious behavior, no prohibited area. Oh, just a camera and a narrative built on elevated threat levels. But heightened alertness doesn't rewrite legal thresholds. Generalized fear cannot replace specific, articulable suspicion. Elevated threat levels do not transform ordinary, lawful conduct into reasonable grounds for enforcement. When assumption becomes the lens, everything looks suspicious. And that's exactly why the law requires more than a feeling.
To the other side of the road, if that's all right.
You've obviously got nothing else better to do with your time, have you?
Well, that's not your concern. What I do with my time is nobody's concern but mine.
Fair enough.
Okay? Can I ask you to identify yourself? You haven't got any numbers on your pellets?
1,000.
1,000. And name?
Sarah Bainbridge.
And yours?
2629. You're also on body cam.
Yeah, that's fine. And you're based here?
Yes.
Yeah, excellent.
Well, I'm based out of Darlington.
Right, okay, excellent. Hello there.
Oh yeah, you're
Hello.
right.
This gentleman is filming. He's now refusing to give any details, and
I'm not obliged to.
I can't understand why he's out filming buildings, council buildings, refusing to give any details in light of the incidents that we're having around the area.
And those incidents, whatever they may be, no concern of mine,
But
nothing
I
to do with
don't
me.
know who you are,
Well-
and I can't check you out.
Well, you don't need to.
Yes, I do, because I have a duty of care to
I'll
the
tell you
public.
what it is, mate. It's anti-terrorism.
There's no terrorist threat at the moment.
But I don't know who you
what
are.
What do you mean there's no terrorist threat? At the moment, we're still on high.
When he fires back with, haven't you got anything better to do? The shift is obvious. That's no longer about public safety. That's frustration slipping through. It signals that the interaction has drifted from objective assessment into personal irritation. Then she pivots again, referencing incidents in the area. As if crime happening somewhere nearby automatically transfers suspicion onto whoever happens to be holding a camera. That's not how reasonable suspicion works. You don't inherit criminality by postcode. Proximity alone is not evidence. And when the second officer finally frames it as anti-terrorism, that's the escalation move. Take a vague discomfort, wrap it in the heaviest legal category available, and hope the weight of the label does the work that facts can't. But serious powers require serious grounds. You don't get to inflate an ordinary situation into a national security issue simply because the optics make you uneasy.
No terrorist threat at the moment, and nor has there been over the past 5 years, towards any public buildings.
That's a lie, because there was one yesterday actually.
Was there? Well, I wasn't aware of that.
Well,
where was
there
that?
you go.
So where was
we
that?
don't know.
So here.
Yes, it was actually.
Right.
Yeah,
There's one to the council officers as well.
Right. That's nothing to do with me. No
That's why
concern of
you've
mine.
been
How do we know
Well,
that?
Well,
It's just
were
my
they
harassment, your
were they
details.
still outside with a mobile phone?
Look, we're not getting into this.
Well-
I am now asking you to leave the area because I feel that you,
On what grounds?
because you are
No,
alarming the public.
No. Which section of the law? You give me the section of the law, I'll quite happily move.
You just need.
Beg your pardon? I'm just a...
I never said one word.
You liar.
We're filming you as well.
That's fine. It's public.
Just stand here
Perfectly
until you
okay.
move out of the
It's
way.
okay, perfectly okay to film in public, which is what I was explaining to your colleague.
You gave me your details, and I could
Right. So
be happy that there is
my
nothing
details,
untoward.
my details won't give you any other information.
I would like to check you out so that I am happy that I can leave you unattended on the side
You
of
can't.
When Forced Awakenings asks the obvious follow-up whether the person involved in that prior incident was even filming, they sidestep it immediately. No clarification, no connection drawn. Or just a quick pivot away from a question that exposes the gap in their reasoning. Because if filming wasn't part of that incident, then the comparison collapses. Instead, she reframes the issue. Now he's alarming the public, and she wants his details so she can feel comfortable, so she can be happy leaving him there. That's not an objective legal threshold. That's personal reassurance dressed up as authority. Policing isn't about regulating activity based on an officer's comfort level. It isn't about soothing uncertainty with someone else's personal data. The standard isn't whether an officer feels satisfied, it's whether there are lawful grounds grounded in fact. When the reasoning shifts from articulable suspicion to emotional comfort, the foundation isn't legal anymore, it's subjective. And subjective standards are exactly what the law is designed to guard against.
No, you've got no actual reason other than curiosity as to why I'm filming to be stood here
I want
asking.
to know who you are
Well,
to make sure.
I don't have to identify myself, and you're well aware of that. I know the law just as much
Very
as you.
shortly, I will to prevent a breach of the peace.
You can't prevent a breach of the peace
can prevent
if
a breach
none
of
was
the
going
peace.
to take place. I'm not breaching anybody's peace.
I have colleagues and members of the council staff who are very concerned about why you were out here filming in light of the incidents
I'm
yesterday.
filming a story. I'm not filming in light of those incidents.
Well,
those incidents
until
weren't
I
even
can-
known to me until you made them aware.
Prove or negate either way. All I want is your details to make sure that no members of the public are a threat
They're
by
not.
you. Well,
My details wouldn't give you any more information about that.
people tell me every day
Well,
how good they are.
I'm not saying I'm not saying.
threat.
Hang on, I'm not saying I'm good. What I'm saying, I'm not denying either way.
Everybody says all the time with interactions with the police. It wasn't me.
That's because
I'm no threat.
That's because your interaction, instead of accepting what I'm doing is perfectly legal.
Then she reaches for breach of the peace. And again, it's floated without foundation. There's no violence, no raised voices, no gathering crowd, no sign of disorder building. That power isn't a comfort blanket to throw over a situation because someone feels uneasy. It exists for imminent conflict, not speculative tension. She adds that colleagues and council staff are concerned. But concern is not evidence. Discomfort is not a legal threshold. Public servants don't get to convert their unease into enforcement authority simply because they don't like being filmed. They're operating in a public-facing role. I'm not defending private living rooms. Lawful filming doesn't become unlawful because it attracts attention. Then comes another broad stroke. I can't just take your word for it. Lots of people say they're innocent. That reasoning skips a step. The burden isn't on the citizen to prove innocence in a public space. The burden is on the officer to identify specific, objective grounds if they're going to escalate. You don't discard someone's explanation by default and replace it with assumption. Policing isn't about filling gaps in evidence with suspicion. It's about working from what's actually in front of you, not what you fear might be there.
Is to cite laws that don't exist. Say that
Cited a law that doesn't
you
exist.
told me that you were going to move me. You can't move me without that section, without the powers under a section.
I have reasonable grounds to believe you.
If you're asking me to move,
Yes.
right, and you can state me a section of the law, I'll move quite happily. That's a perfectly reasonable request.
It's fine because we've got supervision
Do you
coming in.
understand what the current level of threat at the moment?
Right, if there has
You know
been,
what the word evident means? I'm sure you do. You seem like an intelligent
if there
person.
has been a threat yesterday of some sort, then yes, I can understand.
Right. So
But
now you understand.
but I wasn't aware of that until you told me.
Right.
And
So now that's why we need your details.
well, you don't need my details.
Yes, we do.
So do you have the details whoever it was who you spoke to yesterday?
You know what's going to happen, right? I'll tell you exactly what's going to happen. You're going to end up getting arrested.
For what?
Right? Listen,
No, for
we're
what?
speaking to a supervision at the moment, okay? Based on the current threat levels and the incident that happened
now we'll
yesterday,
get an
that
order out.
will ended up getting seized, okay, under the terrorism laws.
She keeps repeating that she has reasonable grounds, but when he offers the simplest possible test, name the section and I'll comply. There's nothing. No statute cited. No specific power identified. Just silence. And that pause speaks volumes. If the authority were solid, it would be easy to articulate. Lawful powers aren't secrets. They have names, they have sections, they have thresholds. When none of that materializes, the claim starts to look less like grounded authority and more like assumption. Then the energy shifts again. The second officer loses patience and jumps straight to arrest threats, floating the idea of seizing his camera under terrorism legislation. But notice what hasn't changed. The facts. There's no new behavior, no new intelligence, no escalation from the citizen. The only thing escalating is frustration. You don't fill a legal vacuum by raising your voice. You don't strengthen weak grounds by invoking the heaviest powers available. Serious legislation requires serious justification. And when escalation replaces explanation, it exposes the gap it's trying to cover.
Your body cameras will also be made public knowledge to me, and I'll use them.
That's fine. I want to know.
I just
we wanna
can't
know
see
who
why
you
you're
are.
being
Well,
so obstructive.
I'm not
Come
being
along.
obstructive at all.
You are being
I'm
You
not
are.
obliged. No, there's no obstruction because I'm not obliged by law to give you
Well, that's fine,
unless
you
you
can fight
reason
that in court then.
unless you
Yeah.
reasonably assume that I don't need to because it wouldn't go to court.
Well, you're being
You'd be looking at a lawsuit.
You're being obstructive. I don't care.
I'm not being obstructive at
I
all.
don't care.
refusing to give my details when being asked is not an
Listen,
obstruction.
you've asked for our details, okay?
Because I'm, as a member of the public,
Yeah.
and you being civil servant, you are legally obliged to give me those details upon request.
You've obviously got nothing else better to do.
Well, but that's my concern, not yours.
Yeah.
If I was stood on the other side of the road without a camera, you wouldn't have approached me. It's purely because I'm filming. Filming is a perfectly legal activity.
Because we don't know why you are filming.
But I've told you why I'm filming, for a story.
A story for what?
For YouTube, for my blog.
Right, so who are you?
I don't have to identify myself. And you're well aware of the law regarding identification, stop and search powers and procedures.
Fight it in court. That's not confidence, that's bluster. It's the kind of line deployed when the justification can't stand on its own in the moment. If the demand were solid, it wouldn't need to be defended by daring someone to challenge it later. Forced Awakenings is right to point out that it shouldn't even reach a courtroom if the initial stop is flawed. That's why civil remedies exist, to address unlawful detention or overreach at the source. The officer's response, "I don't care," is the real tell. That's ego overtaking judgment. Policing decisions aren't meant to hinge on who's willing to gamble on legal fallout. They're supposed to be grounded in clear, our lawful authority from the outset. Then comes the attempted reversal. Because he asked for their details, he should provide his. That's not symmetry, that's misunderstanding. Officers operate under professional standards that require them to identify themselves when asked. Members of the public are not under a blanket obligation to reciprocate absent specific legal grounds. Authority carries duties, citizenship carries rights. Those two things are not interchangeable.
At the moment, my colleagues are on to senior officers so that we can have a power of stop and search to get your details.
Good luck with that. You're detaining me.
I'm not detaining you.
So you just said to me I'm not going anywhere at the minute.
Listen, where do you intend to go next? Because I'm just going to follow you, right?
That's no concern of yours.
Right, well listen, I'm just going to follow you because we need to speak to you about what you're doing.
You can follow me wherever you like,
that's fine then,
but
alright.
don't tell me that I'm not going anywhere
Alright.
because that's a threat of detainment unlawfully.
Right, listen.
Okay.
Would you like to come back round to the police station
I don't
while
need to.
we speak to you?
No, I don't need to.
You don't need
No.
to. Right, where are you going now?
I'm not telling you.
I'm going to follow you then, okay?
You follow me.
Okay.
This is harassment. Yeah, so anyway, I went in to see him and basically fobbed me off back to his offices most of the way. He did say that they would be doing some training over sort of data protection and dealing with photographers. Whether they did or not, I don't know. I didn't take it any further. I wasn't after them for money. It's not why I do this. It's just to show them as the bullies that they were, and hopefully they'll learn.
What stands out most isn't just the initial stop, it's the persistence. When clear authority isn't immediately available, there's no pause to reassess, no reset. Instead, there's a search, consulting colleagues, contacting senior officers, all in an effort to retrofit a power onto a demand that was already made. That's backwards. Decision making is supposed to work the other way around. You identify lawful grounds first, then you act. You don't decide on the outcome and shop internally for something that might justify it afterward. Then there's the following. Once Forced Awakenings disengages and walks away, an officer tails him, asking where he's going as though movement itself requires oversight. "We might need to speak to you" isn't a legal standard. It's a placeholder. If there's a legitimate need, it should already be articulated clearly and specifically. Shadowing someone after failing to establish grounds doesn't strengthen the case. It highlights the absence of one. And the wider significance sits in the follow-up. A complaint is made. The reported outcome? Training on data protection. That detail matters. It suggests the concern wasn't imaginary. Something in the handling of personal information crossed an internal threshold. No dramatic arrest, no viral takedown, just a quiet institutional correction. And sometimes, that's the clearest indicator that the issue was real. If you found value in this breakdown, make sure you like the video, share it, and subscribe to keep this kind of accountability in the spotlight.